Picture this. You are a wedding videographer. You are in a beautiful federal park. Buffaloes are roaming, geysers are geysing. You just got through filming a beautiful surprise proposal when two federales walk up to you with their hand out. Hey, give me some payola. You ain't got no permit. Is that constitutional? Is that legal? Can that happen? Well, not according to United States District Court Judge Colleen Killar-Kotelly. We'll get into that in today's episode. Stick around.
This is the Wedding Industry Law Podcast, a podcast dedicated to wedding professionals that are just trying to keep it legal. And now, your host, Rob Shank.
Out there, welcome back to Wedding Industry Law. My name is Rob, and I am a wedding lawyer. And in today's video / episode / podcast, I'm still working on the rebranding of that. We're going to be talking about a recent United States District Court opinion, which held as unenforceable, as unconstitutional, a statute that allowed the federal government to get money and permits from videographers, from filmmakers that are shooting on federal park land. So the case in which this opinion comes from is essentially a lawsuit filed by a filmmaker from Virginia. His name is Gordon Price, and Gordon Price went onto a federal park in Virginia to film a movie that he was making, essentially an independent, an indie film. And at some point, he was approached by members of the National Park Service. They said, you didn't pay the permits, you didn't pay the money. We're gonna hold you criminally liable. Actually, he was facing criminal charges, and we'll get into the specifics of that later in the episode. But essentially, he challenged that statute that requires permits, that requires money, on constitutional grounds. And again, we'll get into that. But so fast forward, the end result of this case, at least as of right now, is that on January 22nd, the judge in Mr. Price's case issued an opinion which essentially prevents the federal government from permitting or taking money under this statute for filming in federal parks. That's good news. All right, great. Yay, First Amendment. But what does that mean for all you wedding videographers out there right now? Does this same opinion apply to you? And even what about still photography? I know there's a lot of still photographers out there that want to go on federal parks, want to go to Alcatraz, want to go to Yosemite, and do the same thing that videographers are doing. Does this apply to them? We are going to be getting into those issues and what you should do if you're approached by the federales in this episode. But we're not doing that alone. Today, I am super happy to announce that I actually was reached out and he graciously agreed to appear, Mr. Price's attorney in this case, the attorney that argued these issues before this judge and responsible for giving us this opinion. His name is Robert Corn-Revere. Let me tell you a little bit about him. Bob is a First Amendment lawyer and is currently the partner at Davis, Wright, and Tremaine in Washington, D.C., as well as an adjunct scholar at the Cato Institute. So Bob might not be a household name for in your house. However, I know that you've heard of his cases and his clients. So this is just a short list, but in 2004, Bob represented CBS Television and Viacom based on FCC violations because of the Super Bowl halftime show where Janet Jackson had the wardrobe malfunction. So he successfully represented CBS Television at that time. He also represented a Playboy Entertainment Group in front of the Supreme Court of the United States. And in that decision, the court struck down portions of the Communications Decency Act that required cable television operators to fuzz up the screen. So that was a victory for at least many teenage boys in the country. So that's just a brief listing of all the First Amendment cases that he's done. Mr. Corn-Revere actually has a Wikipedia page, and that's where I'm getting a lot of this information from. I'm actually going to link that in the description, along with the opinion that we're talking about, as well as the actual United States code that was held as unconstitutional or found to be unconstitutional by this district court judge. All that information will be in the show notes and in the description below. And without further ado, Bob, welcome to the show.
Thanks for having me.
Can you tell us, Bob, what is the statute that's the basis of this case, and what was the government thinking? What are some of the policy rationales behind why the statute exists in the first place?
Well, the statute was adopted quite a number of years ago, empowering the Department of the Interior and agencies under its jurisdiction to charge fees for commercial photography on lands within its jurisdiction. And it was done for two reasons. One is for resource management, which no one has really disputed as a viable interest. But the other was to provide a, quote, fair return for federal lands for what it described as Hollywood blockbusters and international mega corporations that were using the lands. But what it did was define who had to get a permit and pay a fee based on whether or not they were engaged in commercial photography. And as a result of that, essentially what the federal government was saying was, if you're doing a commercial project, we want a piece of the action.
I see. So I guess it's if the Avengers movie is being filmed and they're going in there and that Avengers movie's, shot in Yosemite, and the Avengers movies makes $1 billion, the government wants their cut because you got to see the geyser in the background. I mean, that one, okay, whatever. I kind of understand the concept of we don't want dump trucks, kind of uprooting trees and things like that. So I could see that being a reasonable understanding of the government.
Sure, and no one ever disputed that kind of resource management issue.
Right.
And whether you're going onto federal lands for purposes of making a film, or if you're taking an army of people onto a federal land for some other purpose, the government clearly has the authority and the mission to manage those resources, make sure that they're not damaged, make sure that the resources are preserved for all of us. But the question is whether or not it can simply say, you're doing something commercial, you're doing something that isn't, and therefore we're going to charge you a fee. And by dividing it that way, it also captured independent filmmakers like my client, Gordy Price, who had made a weekend warrior filmmaker, independent guy, who had gone on to into a federal park with a couple of people and with a single camera and a tripod. So it's not like you're taking trucks and service vehicles and all kinds of other things.
Sure.
Law didn't discriminate between those major productions and Mr. Price.
And even non-commercial, but let's talk about commercial. What can you tell us about the statute as it was and how it defined what commercial was? Like what was that line that was in the statute?
Well, it didn't really, it basically said many of the terms were undefined, but it basically described commercial filmmaking as with the intent to make a profit. And so if, let's say Gordy Price had made the exact same film and he showed it at a restaurant in Newport News, Virginia, and they charged admission and said, okay, that is for profit. But what if he had just made it for his friends and decided, I want to show my friends this film? Same amount of filmmaking, same impact on federal lands. But the difference was that it looked at whether or not his intent was commercial or not. And so the distinction between the two made no sense in terms of the legitimate interest in resource management.
Right. So that would be a great segue into this. So can you tell me what I understand that Mr. Price was an independent filmmaker. He went on to a federal park to make at least a portion of his movie. But what was the genesis of this, of why this lawsuit came about? Like, can you tell me how he got involved with the government coming and knocking on his door?
Sure, it was a sort of a circuitous route, and I think a pretty interesting one. I first heard about Gordy Price from a friend who said he had a filmmaker who had come through other connections to him and wanted to know if someone would help him out. What happened was that after Gordy had made the film Crawford Road, he had had a local premiere, and shortly after that, because that generated a little bit of local press, 2 park police officers showed up at his place of business and said that he had violated the law. He had not gotten a permit for this commercial project. And as a consequence, they cited him under federal law, which carries up to 6 months in jail if you're convicted, and said he had to appear in federal court. So Mr. Price, who was not represented at the time, was in federal court and didn't quite know what to do about it. He wanted to make it go away as quickly as he could. And he originally was thinking of pleading no contest, although he was told at the time, because it was a criminal matter, he had to either plead guilty or not guilty. And so he thought he was just going to plead guilty. The federal magistrate who was presiding over the proceedings told him, not so fast. You should get representation. And by the way, you may have a First Amendment issue here. So
That's a very nice judge.
it's a very good judge who I'm happy to say was looking out for the welfare of defendants that appeared in front of him. He, as I say, through connections, ended up with me, and I decided to represent him pro bono to at least make the court aware of these important First Amendment issues. And so we filed a motion to dismiss the criminal complaint. We raised the First Amendment issues, but because it was in front of a magistrate who was not empowered to declare a federal law unconstitutional, he merely dismissed the charges. And by the way, once the government was confronted with a constitutional defense, they had no interest in proceeding.
Right.
And asked the court to dismiss charges on their own. But at the time, the magistrate said if he wanted to pursue a remedy, it would be by civil action in federal court, which is what we did. After the charges were dismissed, we filed our own civil claim against the government, claiming that the law should be declared unconstitutional.
So that's interesting. So this statute that requires a permit to shoot on federal parkland and money for the permit, it's not simply a civil violation if you don't do what you're supposed to. It's not like an infraction. This is actually a criminal, at least in part, it is a criminal statute in terms of its enforcement. So you can go to jail. That's interesting.
That's right.
Yeah. So, okay. So then you're a good dude. You're a great person representing Mr. Price pro bono. You go to court, and now we have, as of a week and a half ago, I would say a favorable result for you. So can you kind of walk us through what this district court opinion means in the civil case that you mentioned that you filed for your client?
The district court, what was before the court were cross motions for judgment on the pleadings, which meant basically there wasn't a trial, that the judge merely read the legal arguments on both sides and then decided, fortunately, in our favor, and held that the law was unconstitutional, that it essentially violated both the permit requirement focused on commercial filmmaking and the fee requirement were unconstitutional. And this applies not just to the law as a whole, but also the regulations adopted by the Bureau of Land Management, the Fish and Wildlife Service, and the Park Service. So everything under the Department of Interior, that were all the rules adopted. They are unconstitutional and they are unenforceable. The court also issued an injunction against their further enforcement. Now, I should say that there are some limitations on what the court held, and that it went out of its way to say that it wasn't going to issue an opinion on anything beyond the facts of this case. So the facts of this case involve commercial filmmaking. There are separate regulations that apply to still photography. They don't require fees in all the same circumstances, but it left those regulations intact, saying that since Mr. Price was not challenging those specific rules. They weren't part of the ruling. But what it means is, for purposes of the permit requirement and the fee requirement for commercial filmmaking, that those, the law and the implementing regulations are void and unenforceable as of the ruling.
And can you, that's obviously good news for Mr. Price. That's good news for a lot of filmmakers out there. Can you talk kind of briefly about the concept in the district court opinion about why they came to that realization, in terms of, like, we don't want to differentiate, we don't want to have a governmental committee go in and try to understand whether this, Mr. Price's film is commercial, not commercial, and why that is a bad thing.
Well, that's right. And I'll try and do that without getting too much into the ins and outs of First Amendment doctrine.
Sure.
But there were two, I think, really important features of the opinion. One was to issue the ruling that making a film is expressive activity. It's protected by the First Amendment every bit as much as exhibiting a film. I mean, I think it's easy for us to understand that if you're giving a speech, if you are writing a book, if you are presenting a film, that those are all things that are covered by freedom of speech and of the press, and that those activities, the work that goes into it is not just action, it is expressive, and therefore it's protected by the First Amendment. And that was one aspect of the ruling. The government actually made the argument that the process of making a film didn't even implicate the First Amendment, that it was just random action, essentially, and that it was unprotected. So the court cleared that up and made clear, as a number of rulings in recent years have done, that the process of creating speech is also protected by the First Amendment. The other aspect was it broke down the distinction between commercial filmmaking and non-commercial filmmaking. Now, the rules and the law in which, the way it was written, drew distinctions between news, commercial productions, and even documentaries. It lumped in documentaries with commercial filmmaking, and it tried to say that you don't have to pay a fee if you're just coming in with the camera and covering the news. Now, I can understand policy reasons for making that distinction, but in terms of the First Amendment, which protects filmmaking, news production, all aspects of speech, to draw a line between one and essentially tax speech in one instance and not in the other makes no sense. And so the court cleared that up as well, saying that drawing a line between those activities and saying that some are more protected under the First Amendment than others is a violation of the First Amendment. It basically said that that is a content and speaker-based restriction in First Amendment terms, and therefore the government has a heightened burden to justify that kind of restriction, which it held was not met in this case.
So, Bob, can you tell us, for our wedding videographers that are listening, that maybe go into federal parks to do kind of where people spontaneously propose, or even, want to take film that they're going to use for their videos that they have for events, and also to the just the still photographers out there that might go into federal parks, what can either of those categories of people possibly expect? And I know that you're not, the crystal ball or anything like that, but in your experience, kind of where are these two groups of professionals, wedding professionals, where are they at moving forward?
Sure, that's a very good question. I think there are a couple of things to keep in mind. One is that this is still an area that is developing. And as I mentioned earlier, there were certain limitations on how far this decision goes. Right now, we don't know whether or not the government is going to appeal the decision and present it to the Court of Appeals. I think that the decision is based on very solid reasoning. So they, in my view at least, I don't think there's much grounds for appeal. But because this involved striking down an act of Congress, the Department of Justice may feel duty bound to at least take it to the next level of appeal. So we're still waiting to see how that sorts out. Secondly, as was explained in the opinion, there are certain limitations. It did not strike down the rules relating to still photography, even though the reasoning of the opinion would fully apply to any kinds of permit or fee requirements for still photography as much as uh, um, video photography. So, that's going to have to be something to be worked out. And the third practical consideration is the fact that not everyone in the Park Service may have yet gotten the memo that
Right.
This decision has come down. So I think there are practical things that people have to keep in mind if they're planning on going on to federal land and engaging in some sort of commercial photography or commercial filmmaking. They need to be, I think, prepared for the fact that there may be a park police officer or other government official that will ask what they're doing and be operating under a different understanding. It's also worth keeping in mind that the different agencies all had their own individual rules, and different parks had their own procedures for dealing with these things. So again, your situation may vary depending on where you are and how that agency operates. But one thing I would suggest as sort of a practical matter is, if you are engaged in this kind of activity and you go onto federal lands, it wouldn't hurt to have a copy of the opinion from the court with you, so that if you are questioned, you can say, this is a new ruling. It says that what I'm doing is constitutionally protected, and essentially try and speak reason to someone who would question their abilities to do that.
That's great advice. In the last couple minutes that we have, Bob, can you speak to, and I know you said this case is likely going to be appealed because it would be in bad form if the Department of Justice doesn't defend its people.
Well, if I could interrupt for just a
Sure.
second, there's another option, and that is the federal agencies may try and craft different rules. Now, of course, they'll still have to have an enabling statute that they can work with.
Right.
But in the last part of the opinion, the judge wrote that there may be an attempt to write narrower and more specific rules that avoid the constitutional problems.
That was what my question was going to be, is what are they going to do to what do you think this statute's going to look like based on this opinion? Like, I guess I know the government is going to try to get their money, and I'm trying to theorize how they would have to recraft this to get the money. But
Yeah, predicting what the eventual law or rules may look like is always sort of a difficult exercise. But what I can say is, having been involved in cases where federal laws were struck down, I know that like water on pavement, the Congress will probably try and find another channel for adopting some kind of regulation here. I think that there are assuming that the constitutional principles that were articulated by the court are upheld in subsequent decisions or not questioned by the government, there are only certain ways that those regulations can go. For example, to try and draw a distinction between something based on its commercial use or non-commercial use, I think will not be sustained, because in terms of physical impact on the land, there's just no difference unless you're talking about a large scale production, in which case you're talking about a different set of rules. You're talking about the kind of resource management that the government gets to do in any event for any large group. But to simply say that commercial filmmakers and non-commercial filmmakers are going to be treated differently will not fly, I think. And so as a consequence, whatever regulations come out of this will have to avoid drawing those kinds of arbitrary distinctions.
very good. Well, Bob, that's very well said. I very much appreciate you coming on the show, talking about this case, talking about your client. As I said at the top of the show, you're decades into this and a legend, and we appreciate your time.
Oh, that's nice of you to say. Happy to be on the show.
I was not the best student in law school, far from it. I think that I spent more time at Taco Bell than the library. However, I did take a First Amendment course, and I want to say that's the only time in my law school career, and perhaps even, I don't know, my entire collegiate career, that I got the top grade in the class. Then, as a young lawyer, I was required to take the bar exam in 5 different states. So I had to not take the bar exam 5 times in one state. I'm talking about I took the bar exam in 5 different states, passed it in 5 different states. Each one of those states, in some way, tested the First Amendment and the right to free speech. This opinion is 37 pages long, and it still had me baffled despite my experience and my one good grade in law school many, many years ago. But I encourage you, if you have the time, if you are a law wonk or a political wonk, to read the opinion. Again, it's the link is in the description. But it's good reading. It's really interesting sometimes to, we enjoy a result sometimes, but we don't know how we got there. And it's interesting to read that, although even it can be kind of confusing, and I found some of it confusing. But anyway, I hope that you have enjoyed the content of this video. If so, please be sure to like and subscribe, hit that notification bell. It really feeds the YouTube gods and helps me appear in people's search results. If you're listening to this as a podcast, I appreciate you just as much. Your task is to review this podcast so that it also comes up when people are searching for podcasts to listen to. It really does help me out. If you have any suggestions for topics that you want to hear about, then please let me know. I like to say that I get to almost every single suggestion. People have suggestions for me. Like, for example, we had a quantum Merowit episode. That was a result of a listener suggesting that. So if you have suggestions, I promise I'll get to it. And new episodes every Monday, folks. And with that, we'll see you next time.
Thank you for listening to the Wedding Industry Law Podcast. This podcast is intended for general information only. Nothing in this podcast is intended to be legal advice. Do not rely on this podcast for your legal matter. Instead, consult an attorney in your area. Thanks, obrigada, até semana que vem.